Now, one person we did hear from today for the first time, Karen Reed herself, doubling down, of course, saying she did not do this. She wants to know who did.
Said it feels we're the only ones fighting for the truth of what happened to John O'Keefe. And me and my family and my attorneys and my team have marshaled every resource to get to the truth. It just feels like no one else wants it.
Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
And no, she didn't do it. No, she didn't do it. This is an innocent woman. She didn't do it.
I tried to save his life.
Yeah.
I tried to save his life at 6 in the morning. I was covered in the only one trying to save his life.
Why'd you admit to it?
She didn't admit to it. She didn't admit to anything close to that. Nothing close to that. And you should know that.
That was like 3 or 4 times she admitted to it.
No, she didn't.
That's not true.
She asked a question. She asked a question, which is very different. She didn't admit to anything.
You are listening to the Roberta Glass True Crime Report, putting the true back in true crime. From New York City, Roberta Glass is now on the record.
Okay. How is everybody? Wanted to talk today about the one woman who could bring Karen Reed down. And it looks like she hand over the evidence that could bring Karen Reed down? Of course, I'm talking about, can anyone guess? Talking about journalist Gretchen Voss, who has some very damning statements. Appears like from the latest filing from October 25th from the state. They're asking for her notes and her unredacted interviews. Now, if you didn't know, which I didn't know, I thought she had handed that all over, right? You thought, oh man, she handed that all over. What are you talking about? Oh no. What she handed over, let me go to the actual filing and show you. So here's the actual filing. So they say the Commonwealth respectfully requests that this court reconsider its prior order and provide all the sought after information in support of these requests. The Commonwealth, so they're looking for it's Metro Corp via Boston Magazine, which Gretchen Voss writes for, the complete audio record of all the interviews between Gretchen Voss and the defendant, including but not limited to June 20th and July 13th. And it goes, if you go down here, it says, and they're also looking for the Commonwealth respectfully requests that this court reconsider its prior order and provide all the sought after information in support of these requests. The Commonwealth states the following: the defendant has made tactical and repeated admissions outside of court, meaning Karen Reed has made tactical and repeated admissions outside of court regarding her activities during the evening of January 28th and the early morning of January 29th, 2022. The defendant's statement to Voss are not protected by any privilege, and there is no legal basis to limit the Commonwealth's entitlement to all the defense statements to Voss. The defendant engaged in 2 recorded interviews with Voss. The first recorded interview occurred on June 20th, 2023. The Commonwealth was provided a 3-hour and 19-minute recording for this interview. The second recorded interview occurred on July 23rd, 2024. The Commonwealth was provided a 14-minute recording for this interview, right? So you go down to the notes, and it says it informed the court that the June 20th, 2000 interview lasted approximately 4 hours, and the July 2024 interview lasted approximately 2 hours. So there's a big difference between 2 hours and 14 minutes. The interview includes the presence of at least the defendant, the defendant's attorneys. The audios were provided with saturated redactions. The June 20th audio was riddled with approximately 50 redactions. The July 13th, 2023 audio was marred by approximately 100 redactions. Many of the redactions occurred during discussions and admissions pertaining to the critical issues in this case. Many of the redactions include interjections by the defendant's attorney. Oftentimes, when the recording resumes after the redaction, the recording has diverted or redirected to a different topic, one from the one that was interrupted. So she won't hand over her notes. Also from her off-topic interviews, because this was the first time round. We don't know what she's going to do this time round, because she said she was afraid of being harassed. But we know that Karen Reed told her that she made many different admissions as far as her alcohol. Many different statements regarding her alcohol, to I was just sipping water, to, I mean, we can get into it. Let's get into it. So Innocence Fraud Watch did a really good blog about this. I was just sipping water at the waterfall. Apparently that's the first time we've heard this. Gretchen Voss knows a lot, and she's always been sort of heralded by the non-supporters as like a great non-supporter for justice for John O'Keefe. But it seems like she's the biggest supporter of Gretchen Voss and furthering this innocence fraud narrative, because when she first covered this story, did she go to John O'Keefe's family? Did she? No, she went right to Karen Reed and wrote Karen Reed's narrative. So much of the way that you view something is by whose eyes you're viewing it from, right? So you're telling a story entirely told through Karen Reed's eyes. And that's the narrative we've had throughout this whole case. Both sides don't want to veer very far from Gretchen Voss's narrative of this case. If you bring in something else, like how about the last person that she texted right before that was such a source of contention, Richie the plumber? Did that guy ever exist? Why didn't we hear from Richie the plumber? Because John O'Keefe seemed rather annoyed that he wasn't fixing her plumbing issues, her hot water issues, and that she was having a plumber over at 7 and 8 o'clock at night on a Friday night when he could have fixed it because his dad is a plumber easily. But here she is, what I would call abusing him with this plumber story. We don't even know if this Richie the plumber existed. Was he did she really have issues with her hot water? She certainly didn't go back. She went right back to John O'Keefe's house, snuck in like a burglar, and started her plan to cover up what she did, seemed like right away. So let me just share, starting with this is Innocence Fraud Watch's blog. Of course, I'm all the way down on, I won't read all of it, on Gretchen Voss. Make no mistake, Jersey girl Gretchen Voss via Boston Magazine and her amazing fact checker, Makina Jera, were gaslighting and shilling for cop killer Karen Reed. Nastiness. So it starts out, just joined X, but have been reporting the story since late May. My first article came out in October, link in bio, and I've been around and asking questions all along. No time off, just not into the social media nastiness. On May 11th, 2024, during Karen Reed's first trial for her murder, Aidan Turtleboy Kearney linked the following messages from Gretchen Voss, and we'll get to how he's lying about Gretchen Voss, what Gretchen Voss has, and in a second. Aidan Kearney says, Gretchen Voss decided to get ratchet with me today in the media line. Here's what she really thinks of the Keith family and the Dougals, but that was before David Traub got to her with his burger. Yep, this Jersey girl in me was this close to asking Carl's wife, who spent the entire hearing staring at me and rolling her eyes with this disgusting smirk on her face, to take it outside. She wasn't so tough with you after. Nice work, all between us. Oh, wait, she's with CAA in New York. Used her before. I'll send her email before I feed her ravenous animal son some food. By the way, the hostility directed at me from the O'Keefe side at court was insane. I had introduced myself to Carrie before, and she said she wouldn't speak to me if I was writing about the blogger. Dagger stares even from me, from Mrs. O'Keefe. I don't blame Mrs. O'Keefe for giving her dagger stares. Know who the huge fan, bald dude in black shirt who stood near you on the courthouse steps was? So here she is trading text back and forth with Aidan. I have no idea and do not even notice that guy until people showed me his pictures. If these people wanted the truth out and wanted to counter the narrative, then they should talk to you. Instead, they're talking to someone named, I don't know, and that's blacked out. Carl Dougal was one of John O'Keefe's best friends and former Boston PD partners. Innocence fraud grifters. One of the key ingredients of innocence fraud phenomenon is using writers or media outlets to fabricate a leading narrative. John M. Collins Jr., who was a guest on this show way back, you can go back to that interview. I think it's called, what is it called? The Wrongful Conviction of Forensic Science. I think that interview is called, with John Collins, who wrote about innocence fraud in his book Crime Lab Report, which I own. It's like a huge volume of innocence fraud cases. I think it's like $100. Stated in 2014, a common thread in many exonerations is the use of willing journalists to front load a post-conviction investigation with the construction of a compelling innocence narrative. Indeed, this can be a problem in typical criminal investigations where the press jumps to a conclusion about a suspect's guilt. But in post-conviction litigation, the passage of time makes it much easier to sell the alternative story as being legitimate. And that's an excerpt from Innocence Fraud Demands Prosecutors' Vigilance. The same applies to willing journalists who shill for accused killers, especially when their case has yet to be tried in a court of law. The illusionary truth effect. The illusionary truth effect, also known as the illusion of truth, describes how when we hear the same false information repeated again and again, we often come to believe it's true. Clarity and accuracy. What motivated Gretchen Voss to write a story on a live murder case pre-trial, where only snippets of the facts of the case were available, along with a wealth of speculation, innuendo, and gossip? What motivated that? At the foot of her story for Boston Magazine, Gretchen or someone at the magazine, possibly Makina Jera, added the following update: September 27th, 4 p.m. 2 sentences in this story have been revised, one for clarity, one for accuracy. Court documents state that no one else had arrived at 34 Fairview at the time that Colin Albert left. 2, an earlier version of this story characterized Jennifer McCabe's daughter as Colin Albert's cousin. Jennifer McCabe's daughter and Colin Albert are not blood relatives. What court documents were being referred to, and why were they not referred to by Gretchen Voss and Boston Magazine? Manipulation. Gretchen Voss or a colleague craftily used the word clarity and accuracy in an attempt to manipulate her readers, and suggested to the uninitiated of the very real innocence fraud phenomenon grift that the rest of Gretchen Voss's story was accurate. It wasn't, and still isn't accurate. Why didn't Gretchen choose to write her story 7 months before hearing some of the evidence presented by the Commonwealth during Karen Read's trial for her murder? In places like the UK, people like Gretchen Voss and organizations like Boston Magazine could and would be held in contempt of court. Tensions were brewing. Gretchen states in the opening of her tale, snow had just started to fall as John O'Keefe and Karen Read stepped into the Waterfall Bar and Grill on Washington Street, Canton's main drag, on a Friday night in late January 2002 at around 11 p.m. It was the couple's second stop of the night after visiting another popular local pub. Why did Gretchen Voss omit to mention the fact that Karen Read had been arguing with John O'Keefe all day via messages and phone calls, and that Karen Read was also jonesing for a drink at 2:38 p.m., as noted by John O'Keefe at 3:39 p.m. I'm going to grab a drink in a bit, said Karen Read. Wasn't the reason Gretchen Voss did not write about Karen Read's ongoing arguments with John O'Keefe because Karen chose to not tell Gretchen about these continued disputes? And where did Gretchen get her around 11 p.m. time from? John O'Keefe and Karen Read were caught on surveillance leaving C.F. McCarthy's pub at 10:40 p.m. They did not enter the waterfall until 10:54 p.m. Why not? What were they doing for 14 minutes? This is a great point. And it's seldom mentioned because it's not mentioned in Gretchen Voss's article, so it doesn't exist. Why didn't Gretchen Voss explain to her readers why it took Karen and John so long to cross Washington Street? So it goes on how she mischaracterized Gretchen. As the band played on, the mood was festive and upbeat. O'Keefe downed beers while Read drank vodka sodas, lots of them. Karen Read told Gretchen Voss on July 13, 2023, that she did not drink at the Waterfall Bar. According to an October 2024 renewed motion by the Commonwealth, Karen Read had stated, I didn't drink there. She also stated, but I didn't really drink at the second bar. I just socialized. So we know that's untrue. I mean, we can watch her downing drink after drink after drink, one approximately every 14 minutes. Why didn't Gretchen Voss tell her audience that Karen Read had denied drinking at the waterfall? The evidence suggests Karen Read had one Fireball shot, which is whiskey, and one vodka soda in the Waterfall Bar. Not lots of them. Surveillance camera footage caught Karen quaffing the Fireball shot at around 11:46 p.m. Who wanted to keep the party going? Karen did. And so you can see in another blog, Killer Karen Read, retrial Gretchen Voss is a linchpin to exposing murderer and lawyers' innocence fraud. One of the key ingredients of innocence fraud phenomenon is using journalists. And here she is, like a vodka tonic. Here she says in June 2023 that Karen Read lied and said she had a vodka tonic every 40 minutes. Surveillance camera footage from C.F. McCarthy's pub evidences the fact, oh wait, I was wrong. It was around every 12 minutes, not 14, excuse me, that she was in McCarthy's. Even worse. July 2023, Gretchen Voss again interviewed Karen Read on July 7th, July 13th, and July 23rd. Gretchen Voss's meeting with Karen Read on July 7th was an off-the-record chat without her lawyers present and took place in Karen's home at 481 Gilbert Street, Mansfield, apparently to set an atmosphere for Voss's story. So she wanted to get to know Karen off the record, but she took notes, and these are the notes, I believe, that she won't hand over. Gretchen Voss did not record this meeting like she'd done previously, but made handwritten notes throughout. Gretchen Voss again interviewed Karen on July 13th. This interview apparently lasted for 2 hours and was audio recorded. During this interview, Karen told Gretchen Voss that she did not drink at the Waterfall Bar. According to an October 2024 renewed motion by the Commonwealth, I didn't drink there, but I didn't really drink at the second bar. I just socialized. So what is Gretchen Voss really worried about? Well, she's worried about the harassment and intimidation that could come to herself and her family should she hand over her notes, which I assume is the same reason that she's so friendly with Turtle Boy. On August 25th, DA Michael Morrissey released a video statement condemning Karen Read and her innocence fraud enablers and their harassment and intimidation of witnesses. Let's take a look at that real quick in case anybody's forgotten that.
This will be the first statement of its kind in my dozen years as Norfolk District Attorney. The harassment of witnesses in the murder prosecution of Karen Read is absolutely baseless. It should be an outrage to any decent person, and it needs to stop. Innuendo is not evidence. False narratives are not evidence. However, what evidence does show is that John O'Keefe never entered the home at 34 Fairview Road in Canton the night he died. Location data from his phone, recovered from the lawn beneath his body when he was transported to the hospital, shows that this phone did not enter that home. 11 people have given statements that they did not see John O'Keefe enter the home at 34 Fairview that night. 0 people have said that they saw him enter the home. 0. No one. Some have, without any evidence, pointed to 18-year-old Colin Albert, a nephew of the homeowner, and accused him of attacking John O'Keefe as he entered the home. But phone evidence shows O'Keefe never entered the home at all. Testimony from witnesses tell us that 18-year-old Colin Albert had left his uncle's home before John O'Keefe and Karen Read had arrived outside the residence. There was no fight inside that home. John O'Keefe did not enter the home. Colin Albert, the young man being vilified, was not present when Read's vehicle and John O'Keefe arrived on the street. This is a...
Right. I mean, it's so dumb to think that a police officer would just throw someone out of their home and put them on their front lawn. I mean, it's so dumb. This conspiracy theory is so dumb.
A false narrative. Colin Albert didn't commit murder. Jennifer McCabe, Matthew McCabe, and Brian Albert. These people were not part of a conspiracy and certainly did not commit murder or any crime that night. They have been forthcoming with authority, providing statements, and have not engaged in any cover-up. They are not suspects in any crime. They are merely witnesses in the case. To have them accused of murder is outrageous. To have them harassed and intimidated based on false narratives and accusations is wrong. They are witnesses doing what our justice system asks of them. The autopsy of John O'Keefe was conducted by a forensic pathologist from the Office of the Chief Medical Examiner. The doctor found that the injuries that left John helpless in the cold were not a result of a fight. She further found that the line of abrasions on his arm was consistent with blunt trauma, not an animal attack. A grand jury of everyday citizens heard the documented evidence and testimony before making a decision. The subject of that murder indictment enjoys the constitutional presumption of innocence. Why should the witnesses who have committed no crime be afforded less by members of the community? They should not be harassed for telling the government what they heard or saw. I'm asking the Canton community and everyone who feels invested in this case to hear all the actual evidence at trial before assigning guilt to people who have done nothing wrong. And certainly before taking it upon yourself to harass citizens who evidence shows have done nothing in this matter but come forward and bear witness.
But I mean, that's really what innocence fraud is all about. It's the great reversal, so that people who are really just truthful get painted as villains and criminals, and the criminals get painted as folk heroes. I mean, it's the ultimate reversal. And if you don't think a lawyer can manipulate evidence and make good people look suspicious on the stand or shady or like they're hiding something, then you haven't been watching enough trials. You know, this and the purpose of this innocence fraud campaign is to hopelessly bias everybody against these witnesses so they can't hear it. So when the Free Karen Read people can't hear Jen McCabe's testimony, they can't hear it. They can't hear the testimony of the O'Keefes, Michael Camerano, who I think also held back in his testimony because apparently he told the grand jury that Karen Read and John O'Keefe, that John O'Keefe was annoyed with Karen Read that day, but that we never heard that in court. So these witness and harassment campaigns work. But really, it's what it's about, is turning things on its head, innocence fraud in its essence, making something untrue look true. I mean, it's making something look like something it's not. That's what fraud is, right?
We try people in the court and not on the internet for a reason. The internet has no rules of evidence. The internet has no punishment for perjury.
Right, well, you can't just try them by Netflix documentary and and YouTube show. I'm shocked.
And the internet does not know all the facts. Conspiracy theories are not evidence. The idea that multiple police department, EMTs, fire personnel, the medical examiner, and prosecuting agencies are joined in or taken in by a vast conspiracy should be seen for what it is. Completely contrary to the evidence and a desperate attempt to reassign guilt. Michael Proctor, the state police trooper, being accused of planting evidence outside 34 Fairview Road, was never at Fairview Road on the day of the incident. Proctor and his state police partner traveled together the entire day while other officers were processing 34 Fairview. Trooper Proctor was not there and did not plant evidence at 34 Fairview Road. In addition to having no opportunity to plant the evidence, as has been suggested, Proctor would have no motive to do so. Trooper Proctor had no close personal relationship with any of the parties involved in the investigation.
But he did have Karen Read's number, which is why he had to be made public enemy number one. Because he saw through Karen Read and he recognized her guilt. So Karen Read made him public enemy number one and made sure that to make a federal investigation to get his phones, to make sure that anything that he wrote in private that might be embarrassing would come out in public and totally ruin what was a stellar career in the police force. And how disgusting of the Massachusetts State Police to fire him if that's what's going on. Absolutely stomach turning that they can't stand by their officers and cower under this innocence fraud campaign.
And had no
cower and cater to it. That's what I have to say. So disgusting.
conflict.
So angry about it.
and he had no reason to step out of this investigation. Every suggestion to the contrary is a lie. This should be seen for what it is, and not used as a pretext to attack and harass others. What is happening to the witnesses, some with no actual involvement in the case, is wrong. It is contrary to the American values of fairness and the constitutional value of a fair trial. It needs to stop now. I am releasing this recorded statement rather than holding a news conference because my remarks need to be so narrowly tailored to the issue at hand while the prosecution is pending in Superior Court. But the message is the same. What is happening to these innocent people, these witnesses, is wrong and it needs to stop.
So that is his statement, if you've forgotten it. So let me share my screen. Again, just go back to where I was. I'm going to just breeze through this quickly. I just want to talk about the harassment and intimidation. So that was the harassment. This is the reason why Gretchen Voss says she won't hand over her notes. David Traub, a spokesperson for Norfolk DA Michael Morrissey, emailed Gretchen Voss and other media writers and media outlets a link to Michael Morrissey's video. Gretchen replied to David Traub, in part, "I am sure this will bring a great deal of relief to the witnesses," though. No, it brought them, I don't know, I mean, it was a nice try, I guess, but not much. And followed by, "Oh, well, it's not about me, but timing stinks, Ella, please, yes, please, on the burger." So that's the burger. David Traub emailed Gretchen Voss about being careful with language. And Gretchen Voss replied to David Traub 2 days later, stating that she wrongly thought Trooper Michael Proctor was on the scene of 34 Fairview Road on January 29, 2022. Gretchen also notified David Traub that her story was going to press next week and that Makina Jera was her amazing, quote, fact checker, unquote. Then they're trying to get Jennifer Coffindaffer. I mean, this has not been helpful, them getting these kind of people who've come in to play. Jennifer Coffindaffer, who I see as an innocence fraudster. I mean, if you've heard her talk about Delphi, I mean, she thinks they got the wrong guy there. Or last time I checked in with her, she did. I haven't checked in with her recently. And Kate Peter is upping Gretchen Voss with she's a talented writer and an honest and fair reporter. I've had dinner with Gretchen, and I can assure you she's not banging. We're not banging. She's a talented writer, an honest and fair reporter, and a good person. That's why she gets to work in major publications. Really? Those are the things you have to be a good person to work in major publications. So here, this is kind of interesting. David Unetti told me that he demanded Lally call Colin Albert to the grand jury, and then Unetti blamed it on a whistleblower, told them to call in Colin Albert. But we know that Karen Reed, from the evidence presented in court, was crafting this Colin Albert thing from early on. So here's where she says, as noted, Voss has submitted an affidavit in which she avers that the disclosures of the material, this is why she won't hand over her material, will hinder her ability as a journalist to assure sources and that she will keep certain information confidential. Her affidavit also details the harassment she has endured since the publication of her article. Hold on one second, I have to cough. And her fear that if compelled to turn over the requested material, in particular the handwritten notes of the off-the-record interview, oh, geez, that she will be exposing herself to further harassment and endangerment of the safety of herself and her family. Given the extraordinary public attention and scrutiny given to this case, her fears for her own safety and that of her family are no doubt warranted. In light of the concerns set forward in her affidavit, the court concludes that the asserted damage to the free flow of information is more than speculative, theoretical. The Commonwealth has also articulated a strong interest in obtaining the information. So they're trying this time for that. They're also trying, but I think they could be very telling, the unredacted tapes, and why isn't Gretchen Voss handing them over? And why is she seen as such a champion of this side? I don't get it. Thank you, Rena Prattle. Thank you for all that you do. You're welcome, Rena. I loathe Karen Reed, not love, loathe. Okay, we get it, Rita. You loathe her. She is very loathsome. I want to get into your comments quickly before we go into how Turtle Boy lied about this. 1 second.
We got your comments. You had something to say. You were insightful. Oh, so clever. So Roberta's going to read your comments. Hey, Roberta, read those comments.
Okay. CJ SP4 says, I'm so with you. I can't stand how people play down what she did. She freaking floored her car. Good point. 75% down. So 75% down to the floor. 24 miles an hour in reverse. Never once touching the brake. So she freaking floored her car into him on purpose. Look at the evidence, people. Michael Proctor's phone should never have been looked at or brought into evidence. Agree with you there. See-through 1603 said, did her vehicle have the feature that turns the car off before it can strike an object? And if so, is there proof that she intentionally overrode this fail-safe feature? Sorry, I'm new to the case and not sure how sophisticated her vehicle was. No, she did not have that element in her car. It was often discussed, but my understanding is that she didn't have that element of where it stops before you strike a vehicle and you have to override it. But she did have a beeping infotainment system, which would be the equivalent of someone yelling, danger, 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 louder and louder and more insistent in your ear as you're backing up. So when you don't hit the brake or stop as your infotainment system is beeping, that's why it's a murder too. One of the reasons, and never hit the brake. It shows that you willfully did something that could cause serious injury or death. Beth Ryan, 9077. I thought what Proctor said about her was fantastic, coming from someone in the know, stating in several descriptive words exactly what she is. I mean, I have no problem with the fact that Michael Proctor called her a see you next Tuesday. I expect that if I killed a police officer in this way, I would expect the police to talk about me in this way. I would expect it. Also, Free Karen Reed is selling Karen Reed's chewing gum. Who doesn't want that? Don't let me forget this important topic. Nick Rocco. So Tom's CPU stopped by my shop today, probably following Karen Reed around and getting her chewed gum from trash cans, and handed over Karen's used gum from the trial. It's going to be put up as a giveaway. Who doesn't want that, guys? On Sunday at $100 a piece for a used piece of gum. Right? In the meantime, don't forget that Karen's Sweat in a Jar giveaway is still open. You can come back Sunday. Click the link for more easy access. So I don't know if this is a joke or not. I assume I assume it is, but I need more information. Sweat in a Jar giveaway. Who doesn't want Karen Reed's chewing gum? All right. Also, Vinnie Politan dealt with, last time we were here, I believe we were talking about the Karen Reed hearing, where she was arguing that her biggest charges against her be thrown out. And Vinnie Politan had on, I mean, that guy is just shilling for Karen Reed left and right. You got to see this. Had on some lawyers to talk about it, in addition to Kevin Lenahan. Let's take a listen, because he's got to be even-handed, right?
It was the biggest, most divisive trial of 2024. Karen Reed accused of murdering her boyfriend, Boston.
Wait. I almost forgot. I'll get to this. I want to show you how, before this, I want to show you, I almost forgot how Aidan Kearney lied about Gretchen Voss. Gretchen Voss. Check this out.
They've had Gretchen Voss's notes. Like, Gretchen Voss gave them all her notes because she wanted to put Karen Reed in jail because she's not a reporter, she's an activist. No other reporter would ever do that, but she happily handed over her notes to the Commonwealth. They read through them all.
No, they didn't. It's just straight up lying. They read through all her notes. She handed them redacted tapes and no notes. There was nothing in there that was remotely useful. And so that's why you didn't hear about it at all at the trial, because she would like to help put Karen Reed in jail, but she just doesn't have anything to do that. So there's that. There's that. Nothing to see here, guys. Nothing to see here. I almost forgot that. How could I forget that great footage? Nothing to see here. There's nothing worth talking about. Nothing that made Karen Reed look extremely like a huge liar or extremely guilty in that she was lying about everything. Nothing like that. Nothing to see here, guys. All right, back to Vinnie. My apologies.
Officer John O'Keefe. Prosecutors say she ran him over in a jealous, alcohol-fueled rage and charged her with murder. But the defense painted a different picture. A police cover-up spearheaded by the lead investigator, Trooper Michael Proctor, who they say framed Karen Reed for murder. The case divided the community and created a very intense situation at the courthouse. Karen Reed supporters dressed in pink, while those who supported the police wore blue. The same divide existed inside the jury room as the case ended with a deadlocked jury in the 3-count indictment. But after the trial, the defense says 5 jurors came forward to say they actually unanimously agreed Karen Reed was not guilty on counts 1 and 3. But the judge denied the defense request to bring the jurors back to court to find out if they actually reached verdicts on those 2 counts. And
why pink? Why not red? I guess she doesn't want you to think of blood. Pink is kind of inoffensive and kind of nice. Or does she just get a kick of seeing men in pink? I don't know. What do you guys think?
Now, the Massachusetts Supreme Court is hearing the case as the defense tries to get 2 of those counts dismissed.
So much drama throughout this case, and now in front of the Massachusetts Supreme Court because of what happened with this jury at the end. And it comes down to, did the jury find Karen Reed, agree that she was not guilty of counts 1 and 3, which is the top count, murder and leaving the scene of an accident? So there was argument in front of the Supreme Court justices, and there was There was a discussion about exactly how it all went down. Like, how was it that all of a sudden the verdict or the note was handed in, and all of a sudden there was a mistrial and the jury's gone and the defense is wondering what happened.
Wondering what happened. The defense wasn't wondering what happened. They were celebrating. They were hugging Karen Read and celebrating their non-win. They're back to square one. That means they get paid a second time to do the same thing on a case that they've already done most of the work for. They're psyched. They get to do it again. Who cares? They don't care if they lose. It all happened so fast. They didn't know that. Everyone seemed to know but the defense team that it was coming to a mistrial. When the jury kept coming back with note after note after note that they were hopelessly deadlocked.
So I want you to take...
This guy is such a disingenuous douche. I will use Kate Peters' words from that.
Listen to the back and forth in front of the Supreme Court. The attorney you're listening to is the appellate attorney for Karen Read.
They had no opportunity at the time.
First note, was there an argument made concerning ambiguity in response to the first note reporting impasse?
No, there was a request.
Was there any ambiguity argument made in response to the second note?
There was a request for TUI. But the only time that I suggest matters is the third note where they had no opportunity to make that argument.
Why would that be? Why would we just focus not on the totality of the three notes, but just the last note? Why is that, in your opinion, or actually citing any legal authority, why would that be the critical moment?
Because before that, there's at least an impasse on one count, and there is no obligation on a trial court in terms of timing when to seek a partial verdict. When Judge Discassiano asked me for what the three alternatives are, one of the alternatives was simply to ask the jury what it meant. The second was to apply Rule 27B, which says before a mistrial, a court may request of a jury whether or not they've reached any decision on any of the other counts.
The third time, it sounds like that everybody's in an impasse. That's all the information she has.
And that's part of the perils of not providing counsel with an opportunity to be heard, which is what was required.
So something that's happening in all this is that the justices and prosecutors as well are saying, listen, the defense attorneys didn't ask for this jury to be polled. They did not interject. They didn't object as all this was happening, which brings us to our first question of our investigation, which is, did the defense have time to do anything? Did the defense have time to make an objection? Did they have time to interject? Was everything moving too quickly, or did these defense attorneys...
So he's painting it in a defense-friendly way. So you'll see from this, he'll go, well, they had 30 seconds, they had 40 seconds. Is that enough time? So they're making a pro-Karen Read argument in a really manipulative way.
He's dropped the ball inside the courtroom at the moment that the mistrial was declared. Joining me to get to the bottom of it, we've got some great local insiders, criminal defense attorney, college instructor, and author Peter Ellikin, and he served as special trial counsel to Johnny Depp in his defamation case, trial attorney Wayne Dennison. Great to see you both tonight on this. So what I want to do, because there's this argument about this moment when the third note comes out and how it all goes down and why didn't the defense do something. So let's take a look at how it actually went down, and then I want to hear what you two have to say. Let's take a look.
Thank you. Be seated. Closing session.
22-117 Commonwealth versus Karen Read.
All right, the jury is at an impasse. So we'll bring them in.
rise to the jury.
Holly is saying, didn't the defense request the verdict forms to be the way they are? Yes, this is on them. Correctamundo. I mean, this is just something they thought up after the fact to throw out the biggest charges, the strongest charges, the second-degree murder charge and the leaving the scene of an accident causing serious injury or death. I mean, if it doesn't break your heart looking at Paul O'Keefe there, I don't know. You're just not human. I mean, when is justice going to come for their family? I mean, if any of the O'Keefes want to talk or any of John O'Keefe's friends, they always have a platform on this channel, certainly. So sad. You know, and Karen Reed might get away with this. You know, this witness harassment campaign is real and scaring people like Gretchen Voss, who's hiding her notes and redacting her tapes and protecting Karen Reed. She might get away with it. And they're going to people like, you know, the state. I mean, there's been mistakes, you know, made by the state going to people like Jennifer Coffindaffer. And even when, you know, I feel like the spokespeople for this side of the fence aren't really telling it like it is. This is not a unique phenomenon, this innocence fraud. It's only unique in that it's happening pre-trial. But I mean, how many of these we've seen? And people are staking this, they're staking that this Netflix, like putting all their hope into the Netflix basket that like, oh, once Gretchen Voss's documentary, maybe get to that in another episode, comes out on Netflix, it'll really tell it like it is. How is that going to help if it's coming out this summer or later? These things are always delayed. How is that going to help after the trial? I don't mean to be a gloom and doomer, but you know, I just don't see how these things are going to help. People have to start calling it like it is, you know?
Court is in session. Please be seated.
All right, Mr. Foreman, I am in receipt of your note. Judge Cannoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs.
i.e., we have a turtle rider on the jury, and they won't look at the evidence. That's what I hear when I hear that. I don't know what you guys hear. They won't talk about the evidence. They just keep saying she's innocent over and over again, and it's all a big cover-up.
I'm not going to do that.
And keep calling us stupid. I mean, that's basically what I get in the comment section. You're an idiot. You're stupid. She's innocent. Because nobody can actually articulate this cover up from beginning to end and what really happened. They'll just put out shadowy ideas like the tape was reversed. It was a mirrored image we looked at on the Sallyport tape. Conspiracy, huge conspiracy. What difference would it make if it were the other way? None whatsoever. Oh, really? Okay.
You folks, your service is complete. I'm declaring a mistrial in this case.
Okay, there you have it. Peter Ellick and Wayne Dennison, as we look at what happened here, I'll put it up on the screen. And so we can answer the question whether or not the defense had time to do anything here. From the time the judge announced an impasse to when the jury entered the courtroom was 30 seconds. Okay, 30 seconds pass. From the time that the jury enters the courtroom to the judge begins reading the note, another 38 seconds passes. And from the time the judge reads the note out loud to declaring a mistrial is 49 seconds. Peter Ellick, you've tried hundreds of cases. Was there enough time here for the defense attorneys to do something?
Probably not, because she didn't even say ready to, she didn't give anybody an opportunity to talk. She didn't. Normally the defense counsel, the prosecution would weigh in on what do you want to do, what do you want to do now, the judge would ask. And nobody was asked those things. And so simply she said, you're in an impasse, you're dismissed, and that was it. So again, but the question is, could somebody have leaped up and yelled or something? No, we want to be heard. And I guess maybe that's the issue here. And
well, does that happen, Peter? Do defense attorneys jump up and yell? I think I've seen it once or twice.
It's happened, I think, in the realm of possibility here. One of the things that is,
but I think what's more telling is where they cut it off, the tape. You don't see them hugging each other and celebrating. They weren't concerned walking out about what the jury was. Only later, when the turtle riders went right to, from the jury went right to the
really
defense
confusing
team.
Here, though, I can't wrap my head around is that, again, I truly believe that they were deadlocked. That that they declared not guilty on both counts. I mean, these fine lawyers are not going to lie. Enough of them came forward afterwards. But why wouldn't they have given any indication? I don't think any of the lawyers had any idea. All they ever heard was that they couldn't come to a decision. And so the thing I can't wrap my head around is if they couldn't come to a decision, couldn't they have at least said, because it was
but everyone makes mistakes. Everyone makes mistakes.
We're deadlocked on the other.
Right. Well, here's what happens in courtrooms, though. Judges make mistakes. They get appealed. It does not impact a criminal defendant, right? Lawyers can make a mistake in a case, and it doesn't negatively impact a defendant. But here, a jury potentially made a mistake, and it's looking like it's impacting this defendant to a certain extent. Wayne Dennison, was there enough time here? Was there enough time for the defense to jump up and do something? We just saw the way it went down.
Yes, there was enough time, and you provided a timeline that was really interesting, but that's not the timeline we should look at, because they knew for days that there was a real possibility of a hung jury here. They'd been grieving over this issue for days. So it's not as if this notion came out of the blue. They had made even a previous motion for mistrial. So at this point, it's not.
So even the civil lawyer who helped out Johnny Depp in his trial is like, the question you're asking is not the right question. You're asking like in terms of seconds and minutes. This has been going on for days. See how easy it is to frame something to make it look like it's something it's not?
This is a new idea. And quite frankly, even if the judge says, hey, we're done, we're discharging you from your duty as a juror, you can jump up and say, Judge, hold on a second. And quite frankly, I don't know a judge who would say no to that.
Peter, the way things were flowing there, would you have jumped up?
Yeah, I might have been a little confused because in all the times that the jury gave messages here, they never mentioned that they were only deadlocked on one of the issues. So I wouldn't have had any tip-off point. In retrospect, it probably.
Well, would you jump up and say, "Listen, Judge, can we?"
Well, I mean, you got to trust this lawyer because he's got many books behind him. He's clearly knows his stuff. Does anyone remember the ad I showed you of Yannetti with all his books? Reminds me of Anchorman. I've got many leather-bound books.
Question this jury about whether or not they're deadlocked on all three charges?
Yeah, that would, I don't think there was any indication of that. I don't think they had any tip-off that was an issue. Maybe they overlooked it. The prosecution, it's their case. They didn't get up and ask that either. And the judge didn't ask it either. And again, under law here, the judge is not required to do that. A lot of judges would poll the jury and ask them, which charges are you deadlocked on or not? And a number of judges, another judge might have done it, but under the law, the judge is not required to do that. Maybe this is a lesson for judges in the future as a best practice going forward, that maybe they should ask that. So I guess none of the three asked that. But then, is this such a violation of the rights of the defendant here that I wonder if this is the biggest issue, that the fact that we now know that they were dead, that they...
Yeah, they're claiming double jeopardy, violation of the Fifth Amendment of the Constitution of the United States of America. Hold your thoughts. We've got more to get to here. Coming up next, why doesn't the prosecution want to know if the jury reached a verdict?
At most.
So spoiler alert here, guys. It's because Vinnie sums it up that they don't want to know the truth. The prosecutors don't want to know the truth. They purposely are prosecuting what they know as an innocent woman. This is a line you hear again and again in innocence fraud campaigns, that the prosecutor is so ambitious that they can fully handle and like to prosecute innocent people they know are innocent, and put them away in prison for years and years, won't bother their conscience at all, because they're so ambitious. They just want a conviction that they'll pick any Joe Blow innocent person off the street with no evidence to support it, right? There's no evidence in this case.
What we're talking about here with these juror statements is
freaking shameful. We have such poor true crime coverage that we settle for, that everyone just settles for. I mean, this is really like some bottom of the barrel stuff.
Is a snapshot of the jurors' deliberations.
And don't expect me on Court TV anytime soon. Right? There's gonna be no invitations coming from Court TV anytime soon.
Mr. Jeffrey, tell me what happened that night.
Let me just...
It's Supreme Court. And what Karen Reed and her team is trying to do is get the Supreme Court to tell the trial judge, Judge Kearney, to bring the jury back and ask them if they reached a unanimous verdict on counts 1 and 3, because 4 to 5 jurors have come forward to the defense saying that they did in fact find her not guilty of counts 1 and 3. So I want to play for you the appellate attorney for the prosecution who was arguing in front of that same Supreme Court. Take a listen.
At most, what we're talking about here with these juror statements is a snapshot of the jurors' deliberations, but you cannot short circuit the verdict requirement and rely merely on such a snapshot. And it's important because it protects defendants too. You could imagine a different scenario where a juror comes forward and says, notwithstanding the declaration of a mistrial, we all took a vote and we found the defendant guilty of murder. If the Commonwealth were to come forward and say, effect should be given to that vote, there can't be any serious doubt that the defendant, whether in this case or in a future case, would argue that is not a valid verdict and shouldn't be given any consideration.
Thank you, Janet Gardner, for the super sticker. Nice to see you.
Interesting argument by the prosecutor there, probably pretty valid, although the state doesn't have a double jeopardy issue or the constitutional protection of the Fifth Amendment. Which brings me to my next question, because the prosecution doesn't want the jury brought back. So why doesn't the prosecution want to know if the jury reached a verdict? Why don't they want to know? Still with me, Peter Ellikin, Wayne Dennison, great attorneys, trial attorneys. I want to play one more little piece of the argument from the Supreme Court, which again talks about this issue about what really happened in that jury room as to counts 1 and 3. Take a listen.
He says we should expand our law, as I understand him, to include the Fifth Amendment right and double jeopardy protections as well. What's your response to that? Why not?
I agree with the reasoning of the appeals court in De Benedetto that it can't simply be the fact that it implicates a core constitutional right to allow for this sort of inquiry. And here, unlike
Why not? Why is the Fifth Amendment any lesser of a right than the Sixth?
It's not that it's any lesser of a right, Your Honor, but although it is different than the Sixth in that here there's, a balance of two competing public policy considerations. It's not simply the defendant's right, there's the public's interest and right as well. So it is different than, for example, the Sixth Amendment right.
Well, doesn't the public have an interest in finding out the truth of what the jury decided?
The truth. Wayne Dennison. Isn't that ultimately like the purpose of our system of justice, to get to the truth? Like whether it's the truth of what happened, who's responsible, or whether or not a jury agrees to a verdict. Why doesn't the prosecution want to know the answer to the question of whether or not this jury reached a verdict?
I think there's probably two reasons. One of which is in every single...
Okay, so listen to this lawyer's argument and then listen to Vinnie's summation of it, okay? This is, and thank you, Pula Joe. Thank you so much for the super sticker. Very generous of you. Thank you.
Trial you ever do, and I'm actually trying a case right now in that same courthouse. Every day the judge says you cannot, as a juror, deal with any outside influences. You can't talk to anybody, you can't hear from anybody, you literally can't go on the internet. And what happened here is you've released these people, quite frankly, into the wild on one of the most watched cases ever, and they will invariably have now gotten outside pressure. That's one issue.
Right. Outside media, access to outside media. You're not in the same state of mind as you were. Your view of what happened in the deliberation room can be different from someone else's. You can't go back. I don't think that they're going to be successful, but they may be. They may create precedents with this. Who knows? But certainly Vinnie's pushing for it. Listen to how he concludes what this lawyer is saying. Take a listen. So first reason is that they've been exposed to media and to public pressure. But I'd also include the passage of time, and you have to say it's your memory of what happened last summer.
The second issue is the murder charge, quite frankly, is the only real bargaining chip that the prosecution actually has to see if they can ultimately get a plea deal here. Because that's the charge, that's the scariest charge. And if that goes away, the likelihood of a plea, I think, goes to zero.
The likelihood of a plea is already at zero because it's Karen Reed who's so defiant. And she already told Vanity Fair, I'll never let them win. That would be lying down and let them win. She rather harass witnesses, spearhead a witness harassment campaign, make everyone else out to be the villains in her innocence fraud campaign, torment the O'Keefe family. She loves to do that. And she'll never admit to anything. To admit to anything would be actually to admit the truth. She'll never admit the truth. She's never going to make a plea deal. Ever. Zero. There's zero chances. So I think this lawyer is way off here.
So they're not necessarily interested in the truth is what you're telling me. Peter Ellikin, why from your perspective?
Right. So he gave two arguments. One is that the prosecution wants to keep the biggest charges for a plea deal, which is off the table anyway. There's no plea deal with Karen Reed. So stupid argument there. He doesn't know Karen Reed. One is a good argument, I think, which is that they've already been out in the world. They've been exposed to a ton of media about this case, a ton of public opinion and pressure about this case. And I would add to that also that they will be sworn to their memory of what happened in the deliberation room. And the more there is a passage of time, the more those memories can become fallible. memory is fallible. So, but Vinnie concludes what they just don't want to they just don't want to know the truth. They rather prosecute an innocent woman. They rather have something unjust happen to her and go on just because they're that way. They're big meanies. They're so ambitious.
Why do you think the prosecution wants to know if the jury reached a verdict?
Well, the prosecution remember, the defense is supposed to be an advocate for their client, but prosecution is supposed to be in favor of justice. Why wouldn't they nail this down and get this clarified? And there is precedent for bringing back jurors. They just recently did that with another local high-profile Boston case, the Boston Marathon case. They had to bring some jurors.
Right, and the defense also cited that case in their argument. Boston Marathon bombings.
Back, I don't know if it was a couple of years later or something, so they can do that. I don't see any kind of, there's one thing that I haven't quite understood about the prosecution here is that they must have something in mind, but I don't see any plea deal ever happening in this case. And therefore, if I was a prosecutor, I think I would, knowing it's going to go to trial, I'd want to get rid of my weak charges. That was always the weakest, the murder that they never even introduced any evidence at trial that she definitely intentionally killed him. So why wouldn't you want to get rid of that? And the manslaughter charge is the stronger charge, and that's the one I would be pushing. So I don't know about that, but I think that there is precedent for bringing jurors back, and I think it would really be nice to know one way or another, let's nail this down. Did they, in fact, factually all agree not guilty on the 2 counts?
Yeah, there's been a lot of protection of this jury, and I understand why. This is a very divisive and heated sort of case, but there's a lot of cases like that, Wayne. Isn't there a way to bring the jury in, ask them a very focused question, and isn't it simple? Did you reach a unanimous verdict on count 1? Did you reach a unanimous verdict on count 2? Just answer yes or no, don't tell me anything else. And if you do that 12 times, and if you come back with 12 consistent answers, you kind of get an answer to the question pretty easily without interfering or delving into the process of the deliberations.
I think you could do that. And quite frankly, you're going to get jurors who are going to have to be.
Someone is saying in the comment section, sorry, I just missed it, that Vinnie is being paid off. I don't think he has to be paid off. My experience is that innocence fraud campaigns offer more things than they actually do pay. If you look at the case in the Innocence Project in Southern California, Innocence Project, where a lawyer, and I don't want to get too off subject, but she had a client in prison. She went to the client's friend and had a romance, as much as you can have a romance with someone in prison. He was already doing life, and got him to confess and take total responsibility for her client's crime with the promise that she would pay him a portion of the civil money. So this guy did confess. It was nothing to him. He was already doing life in prison without parole. Nothing was going to happen to him to confess. And they didn't pay him. So he went public with all the racy text messages and stuff she had sent him, and pictures and messages saying, she was getting out a guy she knew was guilty. She was getting me to confess to him. I told him he was guilty. I told her he was a guilty guy, and she got me to confess to his crime with the promise of this $1 million payout. I did an episode on it. It's called Innocence Project Scandal. Just recently, check for it in my lives. But so, that's just one example, but I have many examples where they promise things that they don't ultimately give. So I think it's not so much the payment, it's that it's the side that, it's the money-making side. The Free Karen Read is the money-making side of this case. And that's where his viewership is. And that also he's probably friendly with Alan Jackson and Yannetti, et cetera, et cetera. It's more like the friendships and the relationships and the viewership that really controls the narrative, I think, in this case, rather than that. That's my guess. I don't know. You could be right, but just from my experience, my best educated guess on the subject would be that he's not getting paid, that he's going where the views are, and he's going where his colleagues are, where, but of course he would argue that he's fair and balanced because he has Kevin on later in this for 3 minutes.
Sworn to tell the truth. You're going to presume they're going to tell the truth. And if you ask them very narrow questions, I think you would, in fact, get an answer.
Yeah, and we saw this in another case pretty recently, and I think it was in the beginning of this year, Peter Elkin, in the Murdoch case down in South Carolina. They brought back the jurors because of alleged interference by the court clerk. A judge questioned the jurors in court. They were sworn in. Their faces weren't shown. They were not revealed as to who they were. Only the ones who wanted to come forward came forward. And the judge got an answer. It just seems Massachusetts is very overprotective of anything related to the jury. Like nothing, like nobody goes near a juror ever.
Oh, right. And in this case, it has worked out well. None of the jurors' identities have been revealed. The media was not informed of who they were. Everybody seems to be protecting them. So there are probably ways that they could poll the jurors, even get them to sign affidavits that the court could have control over, or bring them in. I don't know that has to be
bring them in chambers in camera.
They can do it in chambers, so we can keep their privacy intact.
Absolutely.
And we don't have to reveal, because there's good reasons why.
We are out of time. Thank you, gentlemen. I'm Vinnie Politan. We'll keep digging for answers as the investigation continues.
Anyway, that's just a little bit on Vinnie, where they went with that. I mean, why doesn't the prosecution want the truth? Why don't they want to know what the jury said? Why don't they? It's kind of funny. Ridiculous, some more ridiculous media from the Free Karen Reed side. I don't know. Should we watch a little bit more? I don't know. Why not? I'm not going anywhere. I'm just going to call it a night.
Police officer named John O'Keefe. John and Karen were a couple who were practically living together. On the night of January 28th, going into the early morning hours of the 29th, they were out together. First at C.F. McCarthy's in downtown Canton, Massachusetts, then at the Waterfall Bar and Grill, and finally inside Karen's SUV in front of Brian Albert's house, who was having an after party with a bunch of the folks who were at the Waterfall. The big question is, what happened to John O'Keefe after he stepped out of Karen's car? Did Karen run him over, or was he killed by someone at the party? The jury couldn't figure it out, so a mistrial was declared, and now a new trial has been scheduled, and Karen Reed is speaking out about her case and about what happened that night.
What a case, what a story, what a trial. So as we wait for the Massachusetts Supreme Court to make their decision, we wait for the retrial to begin, Karen Reed has spoken out and spoken to Vanity Fair. A reporter with Vanity Fair was basically embedded with Karen Reed for several days and wrote this really interesting article. So what I want to do for you right now is show you an excerpt from that article from Vanity Fair as read by our producers.
Beyond a bar run in the week before O'Keefe died, he had never really socialized with Albert, even though both were BPD, living in Canton, and had McCabe in common. Albert had an alluring reputation. He helped unmask the Boston Strangler in 2013 and capture the Craigslist killer before that. The night he died, O'Keefe was eager to join up for a nightcap. When he and Reed arrived at 34 Fairview, though, she wondered whether they were at the right address. There weren't many cars in the driveway, and Reed felt uneasy. McCabe had conveyed the invitation, so Reed wasn't sure.
You know, Albert also arrested Clark Rockefeller That's a case I find fascinating. I would love to know what that was like. He transported Clark Rockefeller. Looks like he was transporting him on a plane somewhere. Love to know. So if you don't know that case, it's a fake. The guy pretended to be a Rockefeller for years and years and years, and then got caught and killed 2 people back in California when he was young, and was prosecuted for doing murder in California for it. But he got nabbed because of a custody case.
Or how welcome the couple actually were. O'Keefe said he'd check out the scene and report back. But minutes passed without a word.
I got pissed,
Reed tells me now. She knew that a woman O'Keefe used to hook up with lived a few houses down the street.
He's got to be screwing around,
she thought.
I didn't think he was physically incapacitated.
After about 10 minutes of waiting, Reed drove to O'Keefe's house.
There's an admission in the negative. I didn't think he was physically incapacitated. I was just wondering all the time if I hit him. Don't you wonder about things like that? That things that aren't happening or are out of the realm of possibilities? I wonder if I don't know what, I don't even know what would be a good metaphor. I really need to come up with a good metaphor for it. But I mean, things that just aren't in the realm of possibilities happening. I wonder if I'll get arrested for this kind of crime, right? I don't drive and haven't done this kind of crime. Lovely Sphinx says, Roberta, don't call it a night. It's not allowed. Oh, we love you. Oh, that's so sweet. Thanks, Lovely Sphinx. Yeah, this is just kind of just hanging out, watching the rest of it. Just to hang out. I don't know. I don't know if there's anything of real super import in Kevin's part.
Now, she didn't testify at the trial, but that's her story to Vanity Fair about what happened that night. Which brings me to my next question in our investigation. Does Karen Reed's story make sense? Does it jive with the evidence that we saw over the course of months during the trial? Does this story of Karen Reed's, as she told Vanity Fair, does it make sense? Joining me, criminal defense attorney Peter Ellikin and the creator behind the Yellow Cottage Tales YouTube channel, Kevin Lenahan. Great to see you both. Thank you so much. Kevin, I'll begin with you. As you listened to that story, read the story, Karen Reed's version, big picture, does it make sense to you?
Well, I don't know why she'd be wondering whether he was incapacitated when she got home or when she woke up from the nap. It seems very strange to me that she would ever have that thought. I mean, as far as she should know, he should be either drinking at the after-hours party still, or maybe if she's suspicious, thinks he hooked up. But the other thing is, this article might have made...
Or wouldn't you think because of the blizzard that he just slept on someone's couch, but immediately at 4 a.m., she's like, calling in all her friends? I mean, that's the way Karen Reed lies. She asks questions. If she doesn't outright just say it, she said, I hit him. Did I hit him? Is he dead? She knows he's dead. She knows she hit him. It's the way Karen Reed lies. Like, you have to know Karen Reed. Was I abusive, or did we have our ups and downs? You don't wonder about those things unless you did them. Think about your last relationship. Do you worry that you're abusive to your parents when you're not? No, you don't. It doesn't enter your mind. It's not in the realm of possibilities. Oh my God. Kevin Lenahan is still, now purposely, going with this lie that I am Innocence Fraud Watch, that I'd want to keep an entire blog, not under my own name, going, and that I could keep an entire blog and another screen name on Twitter and a Rumble account going with its own material, in addition to my own content and my Patreon. content. By the way, there's a new Patreon episode up about the Menendez brothers. Check it out. But I mean, that I want to do that. That I wouldn't want to do it under my own name. That I live a double life. He's going purposely lying about this, just to smear me. Still going with this BS. I'll show you in a second. And it looks like he's. By the way, I caught his show the other night. It looks like he's starting his own cult by the beginning of it. I mean, the melodrama of the beginning of his show is unreal.
Since a year ago to at least entertain it. But we've had the information from the trial, and the GPS shows, without a doubt, that John's phone did not go in the house. Yet it was found underneath his body at the far edge of the property, which is 80 feet from the driveway. And Karen tells us inexplicably that she watched him walk across the threshold into the house. So how did the phone get to the far edge of the property? And that phone stopped. It moved for the last time at 12:32 and 16 seconds. So not very long after John allegedly would have walked into the house. So there's just so many other aspects of this. This article felt to me like it was written by Karen Reed.
Yeah, well, she's embedded and I guess trying to get Karen Reed's story. So let's do this. Let's take a listen, though, because part of the story is that she was waiting for John O'Keefe and she got angry.
So hold on one second. I'll just show you. Actually, I think I have to take this down. Hold on one second. Share my screen. Here it is. Here he is. When someone, Nurse Kim, was pointing out. I think I called Kate Peter. My apology, Kate Peter. Kate Albert. It happens. What are you going to do? It happens. The other night. And she was asking Innocence Fraud Watch if we were the same people. And here he goes, yes, you are correct, Kim. They are the same. And here's Innocence Fraud Watch saying, Kevin, Nurse Kim, you were both fraudsters. Your intentional spin is see-through. Basically, you are correct. They are the same. Oh, my God. I thought it was your parody account response. Thanks, Kim, for confirming they're the same person. So he's continuing with that lie. No apology in sight for that nonsense.
So let's take a listen, Peter Ellikin, to some of the voicemails that Karen Reed left for John O'Keefe that night.
Now, as far as this first voicemail, what time did this occur?
12:37 a.m.
And with the court's permission, if I could play that for the jury.
Yes.
Third message, what time is that received?
12:59.
John, I'm telling you, kid. Nobody knows what the you want. Pervert.
With regard to the fifth message, what time was that received by Mr. O'Keefe's phone?
1:11 a.m.
Yes, 1 in the morning. I'm with your niece and nephew. You pervert. You're pervert.
And the sixth message, sir, what time was that?
Hey, whoever's just said that Kevin's standing up for truth, why is Kevin lying about me then? If he's about truth and justice, why is he lying about me? Intentionally, why is he sending me letters behind the scenes like, you know what you really feel? Here's what you really feel. You know it to be true. I know why you do things better than you do. Why is he sending me stuff behind the scenes like that? If he's so much for truth, why isn't he correcting these lies? Why is he smearing me? My good name all over town.
Received by Mr. O'Keefe's phone.
1:18 a.m.
John, I'm going home. I cannot babysit your niece. I need to go home. You are using me right now. You're another girl. He's sleeping next to me. You're a loser.
The seventh message, sir, what time was that received by Mr. O'Keefe's phone?
5:23 a.m.
Peter Ellikin, as we listen to those voice messages, is that kind of in sync with what she's telling Vanity Fair about her being angry?
Yeah, actually, I think, some people would listen to that and say, oh, that puts her in a bad light. She's using expletives. She seems really angry. If anything, if she knew that she killed him, why would she be doing message, and increasingly angry? Where are you? Why aren't you getting back to me?
Because that's what people do who commit crimes. They cover it up with stuff like this. Was this guy born yesterday? I mean, what is he talking about? Why would you do that? To make it look like something else? To commit a fraud? Why would she be asking, where are you, when she knows where he is? To maybe make a record like Karen Reed loves to do, make a audio recording record that she didn't know where he was? And so she can make the argument that if she knew she had done it, she wouldn't be so angry.
I'm getting angry with you, on and on. That sounds like somebody who is not aware that he is, that he's dying somewhere. So I think if anything, that would exonerate her. I think, when you look at all the evidence in this case, and I'm not going to go through the long, long laundry list. I've never seen any.
I will. John's DNA on the back of her car, John's hair on the back of her car, Karen's car data, Karen's infotainment system beeping at her louder and more insistently as she goes in reverse, 24 miles an hour in reverse with her foot 75% on the pedal, never once touching the brake. Taillight pieces in John O'Keefe's shirt. What do you want? You want some of it? No time to create this conspiracy because the car was already on the way to the Sally port as the CERT team was arriving. I mean, what do you want? As you look at this evidence, I'm not going to go through any of it. Isn't that convenient?
Thing with so many moving parts in it, but we never saw a smoking gun on this case, did we? Like, oh, this got it nailed, or this absolutely exonerated her, or this nailed her, dead to rights, and she's guilty. We have a lot of little pieces of things, but I think that's one of the reasons why they couldn't convict. That there was she was either found not guilty on 2 of the counts, and they couldn't come to an agreement on the other, or if they were deadlocked on all 3. But I think there's a reason for that. That the evidence just wasn't there to convict.
Let's take a listen to something else.
Why would she lie about it? What would Kevin lie about me taking on another persona? Because that's what abusive people do. They lie about things. They lie and they use untruths to abuse people with.
Else, Kevin, I want to play this. This is the testimony of Brian Higgins, who's at the bar before the after party. He also goes to the after party. And we know that there's a little bit of a history between Karen Reed and Brian Higgins. Let's watch.
But she did not greet you, did she?
I think they kind of went like that in different directions.
Right.
Yes.
Did she greet you?
No.
There's another person who has Karen Reed's number, Brian Higgins. This guy got Karen Reed's number. He was not falling for her nonsense. He's like, why so the love bombing all of a sudden? Those text messages are great. Does anyone remember those from the trial?
Right. So she walked over toward the corner of the bar, and John came over and greeted you, and then walked over and joined her, correct?
Yes.
Karen didn't stop what she was doing once she was over in the corner of the bar and come over and say hi to you?
I didn't have any interaction with her that night, no.
So safe to say that throughout that evening, once she was sidled up next to John O'Keefe or the friends that she was with, she never turned back around and came over and even acknowledged you, correct?
That's correct.
So she basically ignored you the entire evening?
That's not how I interpret it, no.
I didn't ask you how you interpreted it. I asked you what she did. Did she ignore you or did she pay attention to you?
Objection.
You can go ahead and answer that. Did she ignore you?
No.
All right, this is some of the video from inside the Waterfall Bar and Grill. Kevin Lenahan, do you think this is in sync with her not wanting to perhaps go inside the house at the after party because it might be a little uncomfortable after what happened between her?
All I can think about is that football game where Karen Reed got him to a point where there were no cameras. She's very aware of where evidence can be created and how to avoid it. You know, you know what I'm saying? She took him to an area where there wasn't a camera and kissed him at that. And I just wonder what he thinks about that kiss. Was it like looking into the basically like the eyes of evil? Does he like try to wash off her stink every day of his life? Her evil stink? That's what I wonder. That's what I'm thinking about looking at him. My honest reaction. There's some honest reaction, guys. That's what I'm thinking about looking at him. Does he think like, does it like, is the cringe real? Thinking back to that moment.
And Brian Higgins?
Sure, you can start to loosely patch it together, and it looks like potentially Higgins felt a little bit jilted at this point and was interested in her, and that would have made her uncomfortable. Of course, in her Dateline interview that was aired a couple of weeks ago, she made it seem like she was waiting for John to say, hey, it's okay, come on in, you know, which doesn't really make sense. In fact, in that interview, she said that she texted John to see if it was okay and called him. But the phone records show that that's not true. She didn't text him until closer to 1 o'clock, about 15 minutes after she got home. And the first phone call was at 12:33, where she got home at 12:36. She was almost certainly on the road at that time. So the story is ever changing, but you can kind of try to piece together something, I guess, that can look like someone else had a motive to kill him. But the simple fact is that data shows and the physical pieces show that matches it perfectly to her car. And I don't think there's going to be a way to get around it if the prosecution puts that together better in the second trial. The very evidence that they have, they just have to present it better.
Right, but now they're also looking for asking for her car data, which would like not her car data, it's like her, I guess it is her car data, but it shows where she was, like her, what do you call that? Now I'm forgetting the word for it. That shows where you are in your car at each moment. So that would track Karen Reed totally, show what she was doing at each time. If they get that, it's going to be really hard to get around it. But, you know, you look at the evidence they had against her in the first trial. And I think it's hard to say. I don't think Lally was a particularly charismatic prosecutor. I thought his openings and closings were both poor, where he really had the opportunity to really argue. In the closing, it was not strong. Do I think you can win a case totally on opening and closing statements? No. But I just remember being asked when I was a juror recently on a criminal case not to hold it against the lawyers because they were not like the lawyers we see on TV. Certainly Alan Jackson is a lawyer very much like you see on TV. I thought he did a good job. Had there not been turtle riders on the jury, I think she would have been convicted. I do. I think that's where I don't know if I totally even believe this, that we agreed on this and we agreed on that. To the lesser charges. I don't know if I'm on board with that. I just find everyone such an unreliable narrator. I think with a stronger, hopefully with a stronger, sleeker case, hopefully they can convict her no problem. But I think the real hurdle is going to be keeping turtle riders off the jury. The jury selection is going to be the most key thing that they do, more so than gathering evidence. That's how I feel about the second trial. I don't know how everyone else is feeling. That's how I feel.
The other thing from the Vanity Fair article seems to be there's a theme of jealousy, that she thinks that John O'Keefe maybe is hooking up with one of his exes at the after party or in one of the houses in the neighborhood. And that came out through the testimony of Jen McCabe.
I think Lally was just totally unprepared for these innocence fraudsters, lawyers, and campaign, and didn't know how to deal with it. And you can see that the whole state of Massachusetts is capitulating to the innocence fraud campaign. So Hank Brennan, I hope, is streetwise, tough enough ready for these fraud tactics in a way that Lally wasn't. I think that has more to do with it than the presentation of the evidence. Sure, it was slow and it wasn't engaging, but that's why you have 12 jurors. Some will pick up some evidence, some will pick up another piece of evidence, and will affect them more strongly, and you all argue about it in the deliberation room.
Who was driving with Karen Reed that following morning to look for John. Let's take a listen to that testimony again.
She just continuously screamed that. And then as we got by different landmarks, she then started, screaming, asking if John could be at certain people's houses.
And whose houses was she asking if John could be at?
If she could be at house.
Referring to the directions that you had provided the night before?
Correct.
And so that would have been, was a child who was around the age of and your daughter, correct?
Yes.
And there have been some years in the past dating relationship between Mr. O'Keefe and mother, correct?
Yes.
And so Ms. Reed is saying that in the car that morning as you're driving over to Fairview?
Yes, she asked, could he have been with Ashley? And I looked at her and said no, because to me that was a crazy idea.
There's a little mistake there. Why even beep it out if that's the case, if you're going to just say the name flat out? Or maybe is it the first and last name they're beeping out? I can't even remember, but what a terrible job of beeping out names, huh?
Dear.
Okay, Peter Elkin, the jealousy aspect here. I mean, I think there's two ways this could go. It could explain her anger and why she drove away without John from her perspective, and he's in the party, she's afraid of that. But it also can kind of leak into a reason to get mad and maybe hit him with the car.
Yeah, we could just read this anyway. It just doesn't seem to really be clear cut. That again, I go back to the thing is, why is she asking people hours later, could he be here? Could he be there? Why would she, if she knew she killed him, why would she, why would...
This guy's never met a liar before. Because she's trying to simulate what it would be like if you didn't know where someone was, right? She can go back in her memory to times when she didn't know where something was and what she did, or where someone was. This guy is willfully just gaslighting his audience with this nonsense. Why would she do that? Clearly she's innocent. Clearly the only conclusion we can come to is that Karen Reed is not putting on a show. She was really so hysterical. I love when people go, she was really obviously so hysterical. I mean, we see this very differently. I mean, to me, this is like a story of relationship violence. This is the end product of relationship violence. After a long, long, long time of Karen really being awful to John O'Keefe. And this is how they end. How these stories end. This is the worst case scenario. I think he'd had enough. He had already tried breaking up with her right before this, kicking her out of the house, and she wouldn't leave. So I think it has a lot to do with it. I know Kevin was saying on the show, he's looking at the jury for him and he's like, well, this doesn't, relationship violence doesn't, he was using another word for it, but doesn't factor in here. But I think that's the story. I think Karen was very abusive, and I think that she fooled the family for a little while. But anyone who eventually saw the real Karen and saw her guilt became public enemy number one. People who have Karen's number became the villains in this story and had the most evidence against her and had the dirt on her. That's why they were trying to get Jen McCabe's phone. Luckily, that got thrown out. But just for the same reason as Proctor. Get dirt. Disparage their character, in the same way. If you've seen my episodes with DA John Lewin, he talks about that's his approach to cross-examination, which is to bring up anything that will make the jury see the witness in an unfavorable light. So that way you just discard anything that they have to say after that. So if, when he had Elizabeth Loftus up, he showed in 50 different ways how she was an arrogant fraudster, hired gun for the defense. And when it's over the process of 3 days, it took it was a really credible cross-examination. Check out my episode on that. But that's the same technique Karen Reed is using outside the confines of the law. A little bit going, looking for ways to, bring up fraudulent. I think it's the whole Fed case is a fraud and a farce. But that the point of it is not to get convictions. The point is to make it look like something shady's going on and get people's cell phones, et cetera, and get Jen McCabe's cell phone so that she has some embarrassing or personal issue, text, et cetera, bring it up to disparage her character.
Would she just be, giving him like 100 different messages and getting angrier and angrier? Why isn't she getting back to him? So I think there's just so many ways to look at this, but that could be looked at a way to, in her favor again, that she's saying to everybody, where is he? Could he be here? Could he be there?
John? Exactly. All right, stay where you are. We know the first trial was huge, but still to come. Will the retrial be even bigger?
In the town of Canton, we have been subjected to domestic terrorism right here in the...
This is some show nonsense. Let's just go forward.
Relationships with people we love because we chose to speak the truth and stand for an innocent woman that was framed. Our loved ones have lost relationships with people they love because we stood for truth.
Because we stood for nonsense. We stood for a conspiracy theory with no evidence.
It ripples through the community. In the town of Canton, we have been subjected.
Rita is so nuts. So nuts.
To domestic terrorism right here in the United States of America. Let that sink in. Let that sink in. We will not be terrorized anymore.
What it looks like.
Oh, wait, hold on. Can you imagine clapping in court when a murder defendant comes up in? It's so out of order.
Folks, this is what it looks like when you bring false charges against an innocent person. The Commonwealth did their worst. They brought the weight of the state based on spurious charges, based on compromise.
So I want to know, that picture, every time I look at Alan Jackson, I think about, he's married, and I think about that picture of with his hands grabbing Karen Reed from the back with his hands on her breasts. And I think about, when did this start? When did their affair start? To me, I think that my view, I don't think that started then, that night. When did it start? You can see her kind of like looking at her. What is your guess on the Delphi verdict? Lovely Sphinx says, could you create a poll in favor? Sure. I don't know. Certainly that guy has some crazy supporters, Richard Allen. I hope it goes the right way. He has a really high-powered defense team. It seems like they were trying to poke some holes in the phone data evidence. I hope he gets convicted because I think they have the right guy. That's my feeling on it. But hold on. I'll make a poll for you. I just don't, I haven't really been on that case since the beginning. And Here, I'll make a poll for you. Lovely Sphinx. I just don't think I had the interest in that case with most of my audience is that interested. Will Richard Allen be convicted? I hope I'm spelling his name right. Yes. Sorry, guys. Hold on one second. I should just play the video while I'm doing this. Okay, there you go. Here we go. Oh, thank you very much, lovely Sphinx. Very generous of you. Appreciate it. Nice to see you.
Investigation and investigators and compromised witnesses. This is what it looks like. And guess what? They failed. They failed miserably, and they'll continue to fail.
These circus animals went down there to harass the O'Keefe family. Have some respect. A man has died. He has lost his life, and those children lost 3 adults that took care of them.
I believe that she's been framed.
I know what that blue line is all about, and I love that blue line, and I'm very, very proud of them. And I can't believe that they took their friend and put him in the snow.
Because this isn't normal to even be out here in the first place. We have lives every day. I stream.
I respect that blue line. I know about that blue line. I know police officers, and I know that the first place they'd want to hide their crime is in their own front yard. I mean, what are they saying? Makes no sense. It makes no sense. But watch Kate Peter come in and really, this is where, you know, she can really sum it up.
Every day, but it really bothered me that they won't leave the O'Keefe family.
That's why we're here, because they harass the majority win. We are done letting the majority win. You stand for the right thing, even if you stand alone. Even if you stand for the O'Keefe family, we stand for John O'Keefe. This is an abomination what's happening. They're treating this like it's a recreation, like it's fun. Murder trial. Like it's all fun.
I'm not for.
She is so right on for the right on when she is focused. And I mean, she just comes in and doesn't waffle. She's like, I'm so tired of letting the majority win. If you didn't hear what she said, you stand for the truth. You stand for the truth, even if you stand alone. Right on. You're treating this like a recreation. 100%. Thank you, lovely Sphinx. Nice to see you. What's going on with Corey Richens? I got to check in with you. That's a trial that should be interesting.
In Texas, like my colleague here, I'm a Boston kid, but I'll repeat what he said, which is we ain't got no quit.
It was a trial unlike any other, but there's.
We ain't got no quit. I'm a Boston kid, and oh boy, he's a Boston kid making millions. Representing an accused murderer.
There's going to be another one, which brings me to my next question. Will the retrial be even bigger? Still with us, criminal defense attorney Peter Ellikin and YouTuber Kevin Lenahan, Yellow Cottage Tales. Kevin, the energy, the passion obviously was real in the streets. It started to grow on the other side. So as we're getting ready for another trial, from your perspective, is the energy, the passion still there? Does it still exist? Has it dissipated?
Absolutely, and it looks like there's going to be new evidence. So, and also both sides have motioned to postpone the trial until April. There's going to be a lot of new experts that are going to testify for the prosecution. The big new evidence is they should have been able to get GPS from the car, and they weren't able to because the entertainment system's software hadn't updated. That software seems to have finally taken place, and now they're trying to schedule to get that chip off done, where they'll know exactly where that car went with timestamps. So that could really change a lot of what happens here. But I also think we're going to get from experts a better explanation from the prosecution to explain John's injuries, which do understandably, to people in the public seems strange. Like, how do you explain how his lack of other injuries besides what happened on his arm and stuff like that? So I think some of the passions are justified by what looks like odd things, but most of these odd things eventually have explanations. And most of them came out in the trial, but we do.
Do you expect what we see here to happen again? Do you expect this to happen again, or have people sort of forgotten about this and moved on?
Oh no, it's only going to be bigger.
Only bigger. Okay, Peter Elkin, let me ask you. Generally,
I'm the only one who thinks it's going to be smaller. Am I the only one who thinks it's going to be smaller? My experience is retrials are usually, the sequels usually not as big as the original, but I don't know. Maybe you're right. I don't know.
Speaking, I come from the school of thought that a retrial, it's always advantage prosecution. There are some issues with some of the witnesses who testified for the Commonwealth in the first case. What do you think about?
Right. Now Michael Proctor has to get up, if it's true, if the rumor's true, and say, like, I'm Michael Proctor, I'm working for, say, I'm just making this up. This is not true. I'm just making a fictional job up. I work for so-and-so, kitty cat securities. I used to be a police officer, blah, blah. What happened? I got fired. That's also it's not going to be great. What did you get fired for? Well, these text messages. Oh, geez.
This retrial, is it traditional advantage prosecution?
I wouldn't say so. I think it's going to be a very different trial. First of all, I think that they're probably going to be there's an extraordinarily good prosecutor.
Yeah, I think so too, Sinclair Reed. I think it's going to be smaller. I think it's going to be more focused. And I think she could get away with it. I think that, unless you're hip to these kind of innocence fraudsters, they can really bend the truth. And what they do is they really expand the minutia and make the minutia hugely important. And the important things, they obscure totally.
Now in the case who got brought in, Hank Brennan, I suspect it's going to be a little more succinct, that they're not going to have 80 witnesses and anybody and everybody talking about various things that maybe aren't that important. They'll probably be like a bullet, get into the important things. We'll see what new evidence comes up. For example, the checking out the car was just mentioned. The prosecution doesn't know whether that'll help them or hurt them. So this will all be revealed. So at this point, I can't say any advantage whatsoever. Other than the prosecution's still going to be stuck with some of the horrible, horrendous witnesses they had who got caught in all kinds of, I don't have to go into the list of it, but all kinds of misbehavior.
Right, all kinds of misbehavior. Like what? Besides Proctor? Misbehavior, right? There's tons of evidence. I mean, have you seen all the good evidence? Have you seen the evidence against Karen Reed? I won't go into it, but the witnesses were terrible. All the terrible things that came out. I'm not going to list them. What is it besides Proctor that was so terrible that came out against the witnesses? Colin Albert's Bang Bang video? Really? A kid fooling around to a rival budget? Wasn't it a rival team or group? I mean, nothing. They had nothing. Bang, bang. Alan Jackson going around. It was absurd. Bossy Texas chick says kitty cat security will sleep 20 hours a day. So that's what I have for today, guys. I think we're at the end here.
Poor conduct and have been suspended and all that. And you can't get away from that at all. As far as outside the building, I think the passion is going to be, I've never seen any case in all the decades I've been doing criminal law in Massachusetts that had higher passion going on. I mean, we've had bigger cases, like, for example, I just mentioned the marathon bomber case where all those people got killed and maimed and all that. That was different. That wasn't controversial. Everybody hated the, defendant from a bat and nobody debated any facts. We all knew he was guilty, and that was different. This one, though.
This is Sacco and Vanzetti.
Also guilty with a big innocence fraud campaign. Also guilty, done in the same courtroom as Sacco and Vanzetti. little factoid. That's as far back as I can trace innocence fraud that I have in my research back to Sacco and Vanzetti, two guilty guys. Maybe someday, I don't know. I've been listening to a thing by John Beresford on Alger Hiss and Whitaker Chambers. It's called like a typewriter, a pumpkin patch. It's on YouTube. It's a thing he did for, I think, public access TV. It is so good. I could barely sleep last night. I was like, on to the next episode. But I'd love to do some of those old cases. The Rosenberg case is something I'm super interested in. You know, usually these innocence fraud campaigns are attached to a cause. And I would say Karen Reed's attached to the idea of police corruption, right? To be against police corruption and the state big power. Sacco and Vanzetti, it was anti-immigrant sentiment that convicted them. Rosenberg, moral panic over communism, but they were all guilty, very guilty. Read the Rosenberg Files by Ronald Radish, great book.
Same courthouse, just, I don't know, 100 years later, 120 years later. Let me ask you, Kevin, people took this very personally. It became very personal, all the arguments. We have about 20 seconds here. Is that feeling still there, that people feel like they have a personal stake in the outcome of this trial?
Absolutely, and that's something that's going to have to be studied. Is why did this case resonate so deeply with people? Is it the odd things? Is it something about the defendant? Is it the idea of police corruption or power and cover-ups? All of those things are factors. And then finally, the social media and a defense team and the willingness to use bloggers and stuff like that. That's all a huge factor in here too.
All right, Kevin Lenahan, Yellow Cottage Tales, great to see you. Peter Ellikin, always fighting the good fight. Appreciate it. You know, it's frustrating for everyone involved when a jury is unable to reach a verdict. No one really wants to do the trial again, but it looks like that's exactly what's going to happen in Massachusetts in 2025. Now, generally, like I said, prosecutors have the advantage at a retrial.
That is true. I know that when I was a juror, it came back, 11 of us, including me, thought the defendant was guilty. It was a child, having to do with a child essay case over years. And we had one juror that we had to convince. And I was so triggered. I was so glad I kind of just bowed out of the arguing. I did not want to get into convincing this woman. Luckily, we had a lawyer who, she had misheard some of the evidence. She just sort of had a belief, like, you know, I thought he was credible. He took the stand, the witness, the accused took the stand as a witness. And I thought all 11 of us thought he was terrible and buried himself. And she thought he was credible. We're like, what did you find credible? But that took us like maybe 2.5 hours to convince her to change. I mean, I can't even imagine doing that over days. You're really locked in there. So that's what I have for today, guys. Please hit the thumbs up, subscribe to the channel, share this episode. I think, where are we on the Richard Allen? Will he be convicted? 62 say yes. Should it really be, should he be convicted? Maybe that's what I should have asked. 38% say no. So interesting. I'm going to end it right there. Interesting poll. Have a great night, everyone. Thanks for hanging out and listening to this with me. I'll see you. I'm off tomorrow, but I'll see you Tuesday at 6 p.m. Have a great night, everybody.
I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown.
my biggest hit yet. I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system I clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen, like John, you were my mark. My innocence fraud campaign is my biggest hit yet.